The Occupy Bank of Ghana demonstration by the minority in Parliament and its associates, is it in limbo? They have told the world that because of the losses, historic, that the Bank of Ghana has incurred over 60 billion Ghana cedis, and because of the new headquarters that it is seeking to build, at a time when people are gnashing their teeth, can't afford 3 square meals, the governor has failed because inflation is running atop the roof and getting everybody to suffer. So they want the Bank of Ghana governor and his deputies to resign. Unable to get that, they are using demonstration on Tuesday, the 5th of September. But the police is in court saying they cannot hold the demonstration using the routes that they insist they must. The police cite reasons, including the wave of coups in Africa, for their fear. There have been fresh charges for #1. 3 years ago, he was put before court for defrauding many customers. In excess of 16,000 investors. And there is some 1.68 billion Ghana cedis at stake. Nothing has gone on in the trial in 3 years. There have been as many as 36, 37 adjournments. But now, he's been slapped with some 36 new charges. What progress is being made, if any at all? The IGP, those who spoke about and plotted to remove him from office and were caught on a tape which is leaked and now being investigated, are before Parliament admitting that yes, they were the architects of that tape. His colleague says even worse things about him now. This investigation, to what end? And Madam Cecilia Dapaa and her millions in dollars and in cedis, the OSP is fighting the court's order to release her cash and to unfreeze her accounts that have been frozen. The OSP seems to say that it will not do any such thing, so the funds will be dissipated. We'll be right back to find out how exactly he intends to do that. I'm Samson, Lardy, Anyenini. Welcome back. And here is Samson's take. Right to vote. EC must enable and not disable. Dear Electoral Commission of Ghana, Article 45 of the Constitution instructs you, quote, to undertake programs for the expansion, emphasis, for the expansion of the registration of voters, end quote. You are inviting an estimated 1.4 million citizens who are not on the voters' roll to your district offices to register from September 12 to October 2, 2023. Now, almost all political parties have kicked against your decision to limit the process to only your district offices. It is difficult to appreciate why you fail to see the unreasonableness of your decision and the wholesomeness of their opposition. It is sound logic, practical, and fairness that requires that these would-be voters, the majority turning 18 after the 2020 elections, are not put to cost and struggle to register to exercise their right to vote in 2024. Times are hard, you know. Please listen. Use or include electoral areas as centers for the exercise rather than expect some people to travel 50 to 80 kilometers to a district center to register. Why must a citizen spend their day traveling to register, and even that, it is not guaranteed that they will not have to find accommodation and face frustrations over a couple of days to be able to register? The EC is supposed to enable, facilitate, and not frustrate a citizen's exercise of their sacred rights and obligation to vote. It is obvious your insistence on only your district offices with only about 4 offices as centers does not give expression to the constitutional dictate to expand voter registration. It certainly disables rather than enables citizens exercise their right to be registered to vote. In Ghana, one constituency, just one, 10, decided elections in 2008 with less than 5,000 votes, making the difference between the winner and the loser. The general impression that the EC is often unnecessarily difficult, acting as law unto itself, is not good for such a critical public service body. In 2015, you remember, the EC's unintelligent intransigence and unreasonable conduct led the Supreme Court to halt a nationwide district assembly elections because one individual, remember that, one single individual, Benjamin Ayimensa's right to participate was violated with impunity. It cost taxpayers, not EC officers, millions of cedis to reorganize those elections. The court has held in the famous Ransford France case that no one single citizen must be deprived of his right to exercise his franchise, a right the court has held even prisoners should not be denied. Recently, your refusal to agree to even minor changes to your botched CI with resort to the Ghana card as the sole source of identification almost gave a bad name to an otherwise most credible, most reliable identification system for a clean and empowered Ghana. The Ghana card, without argument, will become the sole passport for everything requiring an ID, obviously from 2024. Whatever your reasons, sound logic demands that you listen to the political parties and citizens without whom you have no existence or no job. It does terribly bad damage to your image to have chiefs and the NCCE pleading with you to listen. That is my take. We're right back to introduce my guest to you, and we go into the vexed matters. The country is the only group I have heard about in this country where they were organizing a demonstration and produce rules. What you should do, what you can't do, what you can bring, what you cannot bring. But is it not curious that suddenly the police are directing all demonstrators to the Independence Square? Is that not a fetter on the right?
Say that again, Sam. And so this particular demo, look, the police must give demonstrators the right to go to the Bank of Ghana. They should create a buffer, maybe 100 meters from the bank or 50 meters. But it can be done. In 2014, when Occupy Ghana went to Flagstaff, what happened? Great security.
That these days is becoming almost conventional. That you want to take a demonstration to the Jubilee House. You want to take a demonstration to a certain particular space. The police will say, take a demonstration to the Independence Square. We will ask whoever it is to come and meet you there. Is that something that is anticipated by the law? Is that not breaching the rights?
It's completely breaching the rights. One of the things I mentioned in the beginning, if you remember, is that not only are demonstrations covered under the freedom of assembly, but also freedom of expression. Now, a lot of the times in the choice of a location of a demonstration, where they want to go to, in the choice of the date of the demonstration, these are also intended to communicate other things which are also protected rights under the Constitution. So, for instance, the choice of the Bank of Ghana is not removed from the purpose of the message that is intended to be said. If the idea of Occupy Bank of Ghana is that they want to be able to petition the governor of Bank of Ghana to draw citizens' attention to the failing of the institution, people are entitled to do that. And if we intend to emulate other democracies, whether it's at
the White House
or other seats of government, those places receive the most demonstrations because people want to direct their grievances to persons in authority. So the authority point becomes a central figure of demonstrations. In fact, in Ghana, the historical record that the castle used to be the place where most demonstrations would go to. It's the choice of where demonstrations would happen because it used to be the seat of government. So in 1948, the choice of going towards the castle wasn't a random choice. Secondly, about not only where to go, but also the date. So I'll give an example. We are organizing a demonstration on the 21st of September, Occupy Jubilee House. And we have chosen the 21st of September, which as the day for a demonstration for Occupy Jubilee House. And the choice of the date is not a mistake. It is thought through clearly because it is in Nkrumah that we honor. And the value to oppression is part of the demonstration. That's an expression of what we want to be able to communicate. To ask us to put it on a random day is to deny in essence a particular right without recognizing that other protected or ancillary rights that go with a demonstration.
All right.
And so the practice is something that the courts need to look at, that we are not only, it's not a keep faith exercise, and it's not the place of the police to choose for demonstrators what message they want to send and who to send the message to. If we allow that to continue, we are removing the meaning of a demonstration, and the people might lose interest in it.
Right. My guest in the studio, Mahama Yarga, MP, Boku Central, Mary Awolana, other Executive Director, Ghana Integrity Initiative, Amanda Akoko Clinton, Head of Chambers, the Law Office of Clinton Consultancy. Osman Al-Hassan is a lawyer and former Managing Associate of Atuba and Associates. And I begin my very first question, and this is going to be very brief. You go to court on Monday because the police have gone to court and they want to stop you from demonstrating. They are simply respecting the Public Order Act, Section 1, I think that must be, yes, they are simply respecting Section 1.6, which says when you cannot agree on the route to take and you refuse to postpone, they can come to court and stop you from demonstrating.
Well, I mean, a very good law can be used injuriously by very bad people. The Public Order Act, as the name suggests, is to assist, ensure public order. But clearly, you need to establish that there's a real threat to public order. This is a protest march in which we have not heard one single Ghanaian make a statement that they are going to challenge the protesters, that they are going to organize a counter demonstration. Nobody has said they're going to organize a counter demonstration. So there's really no threat. Secondly, this is a protest march led by members of parliament. And so we are also very interested in a peaceful and orderly march to the central bank and to present our petitions and then to depart peacefully, because our reputations are also on the line. In fact, we'll be watching the police more than they will be watching us. And for every demonstration that I have participated in, we've made sure that the entire march is covered, every angle of it, by our own cameras, so that when there's a problem anywhere, we will all be able to detect who caused it. Because, again, you must always look out for infiltrators. You must look out for, sometimes the infiltrators can actually be, sponsored state security actors. So you can't assume that all the people wearing uniforms and standing there, mean well for the demonstrators. So we'll be watching them more than they'll be watching us.
They say there'll be too much of traffic problem, the place is already congested, and the Bank of Ghana is a security installation, so to speak. The law says if they have reasonable grounds to believe that the event, if held, may lead to violence or endanger public defense, public order, public safety, public health, or the running of essential services, or violate the rights and freedoms of other persons, they must request the organizers to postpone the event to another date or something to the effect. If you don't agree, they should go to court and seek to prohibit it.
So far, I've demonstrated that there's no evidence that there will be threat to peace and security.
They talk about terrorism. They talk about the wave of coups in recent days in Africa.
I was going to come to that. But can you imagine that the Ghana Police Service is telling us that because of a coup in Niger, a country that we don't share border with, because of a coup in Mali, which happened about 2-3 years ago, and because of a coup in Guinea, which happened several years ago, maybe they want to add Gabon. I'm sure they want to add Gabon, which is in what, Central Africa, so far away from us. Many people in Ghana ask where Gabon is located. You see, because of all these, a fundamental right of Ghanaians to express their views about the mismanagement of their financial sector by their central bank cannot be exercised because there are coups in other countries. For me, this is very, very serious indictment.
They didn't say you shouldn't.
This is an indictment.
They said, don't use this route. We'll give you different other routes to use, and then go to the Independence Square and present your petition.
I was in the meeting with the police. They said that because of these reasons, terrorism and military coups, we could not march through Makola Market. We could not march through Opera Square. We could not march through Rollins, Park. I pointed out to them that not many years ago, I participated in demonstrations in which we marched from Obrasport Circle through Makola Market, through Opera Square, by the same central bank that today they think we cannot march to, and we terminated at Hearts Park. So clearly, we have done this before. We've done this severally. What has happened today? What has degenerated about the Ghana Police Service that they cannot police citizens to march along the same routes that they could march through several years ago? If anything at all, these past demonstrations should serve as experience for the police service in how to police people to march along those same routes. So if you could do this several years ago, why can't you do it today? There are precedents. Those same places that say we cannot march through, we've marched through them before. So clearly, these are not their reasons. In fact, at the first meeting, which was the only meeting really, they wanted us to rather start at Obra Sport to Adabraka, take the 10 on the left to TUC building, pass by City House, and terminate at Independence Square. We said, okay, you are so concerned about us going to the Bank of Ghana head office. Do you know City House's Bank of Ghana head office annex? And they were sitting there. We said, see, so you claim you know what are security zones in this country, but you want us to go to City House, but you don't want us to go to the Bank of Ghana head office. If Bank of Ghana head office is a security zone, then City House is also a security zone. But you have no problem with us going to City House.
Okay.
I was in the meeting. So we told them that so far, all that you've said do not establish any of the grounds in the Public Order Act. You haven't established a case of threat to public peace, security. There's nowhere in Accra that you carry out a demonstration and it won't affect traffic. In fact, when they proposed to us to start from Obra Sport and terminate at Independence Square, we said, look, why do you want to inconvenience the public all the way from Circle to Independence Square when we are proposing to start just in front of Parliament House and end at the Central Bank? That's the shortest route.
All right.
And it won't take us long. And the routes we have chosen are very wide and broad. So they have no basis.
On Monday, I've seen that they have filed their process, filed their affidavit. You have also filed yours in opposition. So you go before a court and argue, and a court will make a determination. But let me bring in Amanda Clinton briefly on this. This is a constitutional right. Article 21, 1D says there should be, all persons have the right to freedom of assembly, including freedom to take part in processions and demonstrations. But these must be exercised within certain parameters and in respect for the rights of others. You don't agree with the police that they say we have security concerns, including that there's a wave of coups in Africa lately?
Well, I do think it's a stretch to sort of correlate the wave of coups to something that's going to spill over here, because we've never had a coup, and it seems the NDC are quite confident in taking this to the poll in a few years' time. So I do think that's the wrong argument to have. I do believe in freedom of assembly and expression, and perhaps not couching the law to fit the circumstance in terms of, I mean, I very much understand the police is relying on the fact that, you know, public order, public safety, the running of essential services, etc. But as the gentleman who just spoke has said, these routes have been used time and time again by the same people, and we cannot use the law to sort of skewer circumstances in ways that we would prefer. So it's for the NDC lawyers to counter the basis of the injunction application, and perhaps to not say that they're going to embark on this and nothing will stop them. I think it's better to uphold, you know, the public interest.
Yes, they haven't said they haven't said. Hello, Amanda Clinton.
Just relying on the facts.
Hello, they haven't said that they will go ahead. So they are actually going to court to make the argument that these are bogus claims that the police is making.
Yes, I know, but I think the deputy minority leader was quoted in the press as saying that, you know, it's going to be to uphold the public interest, etc. But I just think that we should decide to just deal with this with the law, deal with it with precedent, and the fact that you cannot use the law to circumvent, you know, like particular areas of the law to circumvent what the Constitution intended when we're talking about freedom of assembly and freedom of expression. And these are routes that have been used. And I just think it's a poor argument to say, you know, let's choose the route for them. It's a bad precedent to keep setting by the police.
All right. Osman Al-Hassan, what's your take on this briefly? The police are simply doing what the law says they have the right to do, isn't it? Okay. Hello, Mary. What do you say about this?
Sorry, good morning, Samson. And not to be repetitive, I believe that what the previous speakers have said is right. I also believe that if there is no cause for alarm, the police should not be putting impediments in the way of the citizens from expressing their constitutional rights. I say so because people, if you do that, the tendency for people to then feel their rights are being suppressed and then also take other routes is likely. We need to be careful in these times that we find ourselves, particularly because of some of the examples Honorable Ayariga is citing as their excuse, to ensure that since the people trust government and since the people trust in their institutions, and they are just going ahead to demonstrate, to show some reservations on what has happened, which they believe should not. And particularly in this instance, that the governor should be compelled to resign. It's a constitutional right for the party. And I believe the party is made up of the citizens. So we should not be seen to be curtailing their rights, citing some examples which are not in our context. And particularly, we say that if there is no smoke, certainly we shouldn't be creating any fire. I don't think there is a need for it.
What do you say, Richard? That one of the concerns is that it's becoming the ritual. You want to organize a demonstration or a protest, a picket or whatever it is, and the police say, march to Independence Square. If it's the Auditor General, will ask him to come meet you there and take your speech or your petition.
Well, thank you, Samson. I think it's a conversation that we have to look at. Does that necessarily violate the spirit and the right for people to demonstrate? The decision to allocate a place, I think that we should look at it objectively.
Other than your choice, how would you feel if you wanted to demonstrate your grievance, for example, to the Electoral Commission? And I remember Let My Vote Count. You know, they had to go to the Electoral Commission's premises. Then the police provided, you know, sufficient barricade, even though in the end, some people were hurt.
Yeah, so I think that the conversation should be looked at dispassionately, to say that the spirit, the essential spirit of demonstration is not hurt by saying go here. If that is a conversation, we should look at it. Now, the decision of the demonstrators to want to go to a particular destination and the position of the police saying that maybe it might be a security zone, and the headquarters, if you've been there recently, I think we all know where it's at, is a very crowded place. And so for me, and we're beginning to see an instance where the police is trying to manage the crowd situation and to prevent unforeseen situations happening.
The fact that it's already a crowded place, does it not defeat their arguments?
Well, you couldn't possibly avoid the organic crowd that is there, but this one you can prevent it, right? So that's really the logic there. But I think that if, on whole, we are going to understand that, okay, well, for certain reasons, we can designate that Independence Square as the converging point for all demonstrations.
You'll be fine with that?
I'll be okay with it, but the only thing is that it has to be consistent. And in doing that, Samson, I think you agree with me, it doesn't take away the inherent value and right of citizens to demonstrate, but it is only helping the police manage the unintended outcomes of, you know, crowd coming together and possibilities of anything happening. And I think we should focus on that.
Okay. Osman, from where you sit as a lawyer, nothing is lost, like Richard is saying. If you don't get to use the routes you want, and if you don't get to assemble at the place that you prefer. And I was having conversation with other lawyers, and the examples kept coming elsewhere. Their presidential palaces are the sign, the place where demonstrations are actually held. In the White House, we know often that is where people head to. But that is them. We can decide otherwise. Please unmute your mic.
Can you hear me?
Yes, please.
Yes. I think after listening, I think we are refusing to see the unity of the purpose of the demonstration and the demonstration itself. You see, and more so, it is not just the right to demonstrate that is being exercised, that's being restricted here. It is also the freedom of movement. Because if you restrict me to a particular place because I am demonstrating, then it is also a restriction of a freedom of movement. Now, apart from restricting me to unify the purpose of my demonstration and the target of my demonstration, you have also asked me not to move beyond a certain point. And to restrict that movement must have a justification. Samson, if suppose that it was not even a demonstration, and you restrict a mass or group of people to a certain space and say they shouldn't move beyond that space, what is that? Now, if you do so, and your reason is that the place the people want to go is rather a place or a security zone. You know, they do these things because there are some restrictions, there are some limitations within the Constitution that is supposed to regulate the exercise of rights. We agree, and national security is one of them. But you see, if all of a sudden a place people have been moving in and out, and people, they say organic presence, people are organically present at a place without any security implication. Now, you say those who are there can be there, but we cannot come there because we want to demonstrate a certain plight to an authority that should listen to us. Then it defeats, as someone actually, as you are rightly acknowledged, it defeats the purpose of the restriction. If actually the restriction is because of security reasons, because why would the place become suddenly a security zone? Security zones must be known. They must be known prior to any action, to any demonstration. They must be known that this is a security zone that we don't want people to move to. But if people are moving in and out, and it's not compromising any security measure, then what is the reason for saying the demonstrating mass should not move to that place? And I think we should situate this conversation in a special context. You see, Samson, if you ask me, this is the time people must be allowed to vent their spleen. This is the most relevant time for the citizenry to be allowed to express themselves however they want to express it, because the consequence of that failure might be worse than what they are preventing. And so, for me, I don't think it is in the place of the police even to determine that this is security zone. And so I think we should look at it again.
All right, thank you very much, Osman Lahassan, and before him you heard Richard Ahiagba, who is Communications Director of the New Patriotic Party. Let me go straight to Amanda Clinton now, because this is an area where she has an interest, because she represents some of the victims of the Menzgold situation. And just to give you an idea of how, huge this situation is, you have in excess of 16,000 investors or customers involved. They have put several amounts of money into Menzgold, and they have lost them. Some, we are told, have died as a result of the situation. Some have fallen ill. Some needed the money for hospital and for medication. They didn't get it. And out of that, a lot has happened. There's in excess of 1.68 billion Ghana cedis at stake. The Attorney General or the state put #1 as in Nana Appiah Mensah, the owner of Menzgold Ghana Limited, defunct, the chief executive officer, before the court in 2019 for dozens of charges over this matter. It's taking 3 years and literally nothing has happened. And then this week, his case was moved from the circuit court, to now the High Court with 36 counts of offenses involving fraudulent dealing and money laundering. What sort of progress is this, if any at all? Amanda, let's start with you.
Thank you. Well, I mean, I completely agree with what you've just said. You know, it's been more than 3 years later. Nothing happened with the initial 61 charges, and it was in completely the wrong court. I think it was in the circuit court. And when you've got this kind of volume of money involved and the amount of victims, we would ordinarily have expected it to have gone to the High Court. But, you know, we're grateful that now at least the matter is at the High Court, and it's actually 39 charges. 25 of those charges are defrauding by false pretenses. It is a little too much too late, but in terms of, you know, all this time has passed. But I do commend the Attorney General's Department for at least saying they were very much investigating the matter. And by reducing the charges to 39, I really do believe it's because they really want to pursue those charges. Attorney General Dami can go one step further, because when you've got money laundering charges, it means that the person was cleaning the money. So I think the public have to be corrected in saying that, you know, the money is gone, it's just disappeared, that's the end of the matter. When you have 25 money laundering charges, it means that the person was cleaning the money, they were liquidating it, they were putting it in cash, and we do know that Nana Appiah Mensah does prefer crypto as well, in terms of one of his uses of currencies is crypto. So it is for the Attorney General's Department perhaps to go one step further and, you know, exercise the international arm of the AG's department to get in touch with countries that he frequented, including South Africa and Spain, etc., to just see what sort of assets he has. And if he's so involved in crypto, also get in touch with specialized departments who, although some people think crypto can't be traced, it can to some extent, to just see how much he's holding in crypto, how much he's holding in other countries, and to get back some of this money for the victims, because it's not too late to get back some of this money. And even though he says, I don't even own a car, I think he very much owns slightly more than a car, even if it's not in Ghana.
Mm. So from, is it 61 charges to now 39 charges?
Yeah.
What's
7 is money laundering, and 7 is fraudulent breach of trust, and 25 is defrauding by false pretenses.
What's the hope that if it has taken 3 years to mark time here, what's the hope that there will be any progress, so to speak, now that these new charges have been put before the court?
I think there is a lot of hope. I mean, I think we have a relatively new Attorney General who's trying to prove his mark in terms of distinguish himself from other Attorney Generals and, you know, possibly to carry on in the party in some capacity. So hopefully that will incentivize him to make a mark. And making a mark, one of the ways you can make a mark is such a high-profile case such as this, and show that without him, you know, there wouldn't have been such a difference. So I hope he's incentivized in that regard. And I think just because of the sheer volume of paper trail, the fact that, you know, it's not like any of this can be denied, it very much helps the state establish a case and go beyond proving the case. And if they have wasted more than 3 years, they would say they haven't wasted it, because it's true, you know, it does take investigation to get a case up to this standard. And I worked at the Attorney General's Department, so, you know, I do know the wheels of justice do take time. But it is for them to go that step further and really assess what is happening to Nana Payments's assets in different countries. How was he holding that money? Because, you know, he was on a lot of flights to South Africa. In particular, every given week he was on multiple flights, allegedly, to South Africa, and spent a lot of time in South Africa and different countries, and Spain and different countries like that. So are these assets there? What's happening to his sister and wife, who are also charged? Do they have some of these assets? And, you know, as a sign of good faith, give it back to the people. And Mr. Mensah also came out saying this week, I think, don't compare Menzgold to DKM. And I would never compare Menzgold, or I think a lot of people wouldn't compare Menzgold to DKM. They would compare it to Piriani, or unless I'm saying it wrong, but that was another Ponzi scheme. Piram. Yes, they would compare to that many years ago. And so if he's looking for precedents of what his operation is being compared to, I think it would be very apt to compare it to another major
some of the customers,
Ponzi scheme.
Some of the customers have been reaching out to us, and they are wondering, what sort of coincidence is this? That practically nothing happens in 3 years, then the man shows his face again, he begins to use a process that they believe is yet another way of defrauding them, asking them to pay some 650 Ghana cedis, you know, to verify themselves, or they lose their money and so on. And some actually subscribe to this. Then suddenly the state is back on his case.
I mean, well, I think rightfully the Attorney General's Department and the President faced huge pressure that, you know, they must be seen as acting, particularly for such a high-profile case. And so they have sent this matter to the High Court. It does seem a little timely, but perhaps we can give them the benefit of the doubt, particularly because it does take a while to truly build a case. For instance, in America, the case against President Trump could have, you know, some people would have handled that immediately. It took years, because what those people are now facing in terms of charges is going to stick. There's no way they're getting out of those charges. And so sometimes it does take the states some time to build a case, but we don't just want, you know, him convicted and, you know, possible jail time, etc. We really want the state to show that we're far more sophisticated in chasing this money. Because if you have 25 or 7 money laundering charges, and there's far more, but they have 7 money laundering charges, it suggests he cleaned the money. He cleaned it so that it moved somewhere. And so it is for the state to show, you know, we're far more sophisticated in getting in touch with our counterparts and trying to keep that money, I think.
My final question to you will be, the people who are speaking of a suspicion that the state did not sincerely intend to prosecute him for reasons including claims and rumors that, you know, he had threatened because he will spill some beans somewhere, he will implicate some people for some wrongdoing, and that he had been a financier of the governing party and so on. It is the reason he was being held by another country through a judicial process, and we went for him and brought him here, saying that we needed him here to face more serious, you know, prosecution, and nothing seems to go on.
I mean, it is a little sad, because a similar thing happened with, I think, the Hush Puppy case, a Nigerian in Dubai. And Nigeria said that we want him. And then the US just took him, saying that they doubted that he would face proper charges in Nigeria. So the US just extradited him and are dealing with him there for crime. And so Ghana must not gain that sort of reputation whereby in future, other countries might not hand back our citizens to us on the basis that, well, this clearly is a case that nothing has been done thus far. And it is slightly timely, not just because of the public uproar. It's also timely because, you know, the government is facing a lot of pressure because of the Dapaa case.
All right.
And so maybe, you know, this is quite timely to take attention away from that case. I don't know.
All right.
But we just hope that it serves the Menzgold's purpose, which is to make sure he faces he faces justice. And the Attorney General's Department does look for this money in South Africa, Spain, and all the countries he frequented.
Okay, I said that would be my last question, but this should be it. Some of the customers are sending me messages, and they want to know what's your thinking when you appear, when the case goes back to court on the 19th of September. What's going to be asked for? That's like Jachi Kwesing, it should be a daily trial for him.
Should happen is that this is very much a public interest case. So I do hope as much of the media shows up to this case and report back if anything is being done, or we're going to have like 36 adjournments. So I think that's the first step, that the media should show up and actually see that, you know, justice is being done. And secondly, I really do think that bail should be revisited. Just because it is a different court, and you know, the other case has died, and so it's been resurrected at the High Court, and so it is for the judge to perhaps consider if more of a bail amount is requested or is needed, and does he have a high risk of absconding if he's even still in the country, because a lot of people online are saying, is he even in the country? And to just address the complexity of this case and revisit, should bail be granted if there's a lot of money involved and he's a high risk, and how is she or he going to counter those arguments, you know, when addressing bail? So I think the media is going to play a very important part in this case, and I think bail should be revisited.
All right. So forgive me again, but you were seeking that there will be some government intervention to the customers, right?
Very much. I do believe that the government has the resources to do this. They have the resources to do this, particularly because of their international counterparts and reaching out and finding out where this money went. And the whole basis of the state's case, particularly the one that they filed, is that he literally used the money as his personal piggy bank. And he did that to move money to brew marketing and to move a considerable amount of money to his personal accounts. And we know the money isn't in his personal accounts anymore because, again, the state took too long to seek injunctions.
Okay.
So the states can go after this internationally, and by squeezing Nanapier Mensah to give up some of this money that actually does exist.
Okay, thank you very much, Amanda Clinton. She's been representing some of the customers of Menzgold and has been advocating very strongly that Nanapier Mensah should not go free, and more particularly, the monies should be found and paid back to the customers, some of whom have died and some of whom are dying, some of whom have lost their jobs, some of them have been put into debt that they never imagined they would find themselves in. Let me get to Mary. Mary, in the new twist of things, people actually believe that this 650 or so that he asked people to send for this verification thing, he's made another, bunch of money in that, and that the government should be interested in presently taking these monies as well.
Certainly. It's interesting, and this, I believe, is one of the saddest cases this country is contending with, apart from the DKMs and others. I believe that Ghanaians have allowed themselves, our gullibility levels are amazing sometimes. Perhaps it's also because of the desperation we find ourselves in. But then I believe that our security agencies should be more proactive than they have done. Certainly, there must have been some intel to the fact that something like this was even brewing. But permit me to say that if they lost that or lost out on that, when this thing appeared, they should have nipped it in the bud from the initiation. Unfortunately, some people have paid. And so this should be a ground for them to hold him certainly accountable for taking, if even it's 50 cedis per person, it's a lot of money. We cannot continue to allow people to perpetuate some of these Ponzi schemes and get away with them so freely. It's beginning to embolden others to want to do more. Security agencies and also the Attorney General, who has already resurfaced again with new charges in this case, should be interested to take this particular one and ensure that those whose monies have been taken are refunded immediately. It doesn't make sense at all. And okay. I believe our leaders or those who have been put in places of power should ensure that they do not allow some of these wicked schemes to manifest themselves in our society.
All right, thank you very much.
We are better than this.
Okay. The Fred Forsing has been identified as the convener of the Menzgold customers, and he says I should be putting numbers to the deaths that have occurred as a result of this. And he says over 210 people have died as a result of this, and people are going through daily travail because of this. So they need their money as quickly as possible. He says that if you look at count 31, Abigail, that is Namwan's sister, who in 2019, 2020, told them that they won't pay the customers because if they did, her brother will become poor. Allegedly, 66 million of their money was given to her by Namwan. And also the recent 650 Ghana cedis to verify your status and so on. She is part of that, that structure. He says a Momo merchant, 10 millionaire overnight. Something must be done and quickly. Yes. Richard.
Well, it's very sad. There's several angles to this number one issue. The first primary one for me is the people who sadly are caught into this. Of course, we had a conversation about their seeming believability of a company whose modus operandi
took their savings from banks.
Yes, and interestingly, gave it all their savings in most cases, and in fact,
especially people in the security organizations, the soldiers.
I mean,
police.
I don't know if the individual practices hypnotism on, I don't know, because incidentally, come back and say people should pay some amount
and they believe
to verify investment, which perhaps they have certificates to before they can be ascertained as having been investors in the business. For me, it's very shocking and very sad. So that part, I think that we sympathize with all Ghanaians. Yes, we can say they were gullible and all of that. Their own faults in terms of judgment going into it cannot be the center of conversation. Anybody could have fallen for it. In fact, the evidence that a lot of people fell for it means that it has some believability to it. So that part, I think that is clear, and we sympathize with the people, especially now knowing about some 200 or so people having perished because of the investments being locked there. So certainly, I think we should sympathize with people and then also support the idea that whatever assets he has and investments elsewhere should be found and applied to pay the people. But my understanding is, your good self, a lawyer, can guide the conversation, is that it's a process, isn't it? That it's a criminal case, and so you have to go through the processes for a judgment whether or not he's guilty or not, and then decision on the assets will be made. Now, so if that is the case, then I guess that we should commend the Attorney General now appropriately taking steps to have this case probably be looked at the appropriate court now to come to a conclusion as expeditiously as possible so we can get to the point of settling the liabilities of the company to its customers. I think that
they feel government can make some advances to them, to sort of cushion them somehow, because they can't be waiting forever. It's been 3 years of an attempt to prosecute and nothing has happened yet.
Yeah. Well, I think that's a fair request to make, but of course it's not one that government has to do necessarily because of the situation. But it's a compassionate call that I think that if conditions were right, if the advocacy is pursued to the point it has to be, I think that if government is able, they will. But the substantive matter is how to get the culprit, if you like, who has defrauded people, given the assumptions allegedly that we have seen, even in the case I was just reading through the charge sheet and seeing the kinds of counts that have leveled against him. I think that this whole number one issue is one that we all as a people need to look at. But of course, where we are now, I think the lawyers, or I think Madam Clinton is the lawyer for the customers. I think her position of drawing the media into this, I guess, is one that is welcome. But my understanding is also that the Attorney General, with the new charges that they've brought against him, is committed to have an expeditious trial. So perhaps we will see, as you are asking, a daily trial of the matter to ensure that the case is decided quickly, and so we can get to addressing the primary concern of the But the one small point I want to make is that people should not get into the space of trying to look at this as perhaps the initial attempts were slow, because it's a very complex case where you needed to understand, it's a technical space, you need to understand the full facts of the matter and understand the complexity of the investment he was doing. It was a novel thing. I don't think that we've had a similar transaction.
You think that's a good excuse?
I'm saying that
by the time the charges were filed, the state was clear about what was at stake.
Well, it was clear that he's violated some...
so, in fact, in the new charges, really nothing much has changed, from 61 to 39 of them. Just that some of them you feel they are not necessary, they won't, avail you anything, so you take them off.
As I'm saying, as a lawyer, you know that. So now that a conscious effort has been made to distill the charges, and so that shows some new energy and commitment to want to go to court with the proper case that they know can then deliver the judgment they're looking for. And also the presence of mind to bring the case to the right court with the proper jurisdiction to address the matter. It's also, for me, is one that would commend.
Thank you. Yes, Mama Yaga, which angle are you looking at this? They're saying the state confiscated some assets, some properties belonging to number one. They want to see, to what effect. It's been 3 years.
Well, this is very sad. And if you ask me which angle, I will say, let's look at it from the right angle. Everybody seems to be running away from looking at it from the right angle.
Which angle is this?
You have a constitution that says that the Attorney General and Minister of Justice shall be responsible for initiation and prosecution of all criminal matters, and that all criminal prosecutions must be done in his name. And this is an Attorney General that is taking 3 years, not 1 month, not 2 months, not 1 year, not 2, 3 years to decipher what are the appropriate charges to prefer against Nana Mensah.
No, there were 61 charges already.
But they just dropped and changed to 39.
That's right.
Is that not it?
Yes.
So it means that it has taken them 3 years to figure out that the 61 were wrong and that it is this 39 that should be the proper charges. And it's taken them 3 years to figure out that they had filed the matter in the wrong court and that it is the High Court, that is the proper court. What other evidence of incompetence?
Because you add money laundering charges will have to go to the High Court rather than the Circuit Court. So that's
and it's
that's,
taken 3 years. It's taken 3 years for the Attorney General of Ghana and the Minister of Justice to figure out that for a money laundering charge, you should go to the High Court, or that this fact, which clearly shows money laundering from the very beginning, it is only after 3 years that the Attorney General of Ghana is getting to know that he should add money laundering charges, and therefore he should go to the High Court.
Prosecutors amend charges all the time, but what's the new angle?
And it is taking 3 years, 3 good years. We are talking about the fate of 16,000 Ghanaians.
Almost 40 adjournments.
Whose tax money is what is used to buy the luxury car that the Attorney General is driving in, and the comfortable office, and his luxurious travel expenses at the cost of the taxpayer. And these taxpayers have been defrauded by NAM1, and it's taken 3 years for this very competent Attorney General.
These are taxpayers who were warned and they ignored the warnings, even at times when the state intervened. They were rather with the man against the state.
That is even worse, because the state sat by, the Bank of Ghana, the police, the security services, the Attorney General, everybody sat idly by and allowed this man to defraud citizens. Even if the people giving the money were participating in the conduct, they were also committing a criminal offense, and the state had a responsibility to stop them. From the very beginning, I said that this is fraud. This is obviously fraud. Look, what are the charges? Minerals and mining law related offenses, selling gold without proper license or buying gold without license.
Largely fraud charges.
Largely basic fraud charges that first year criminal law. Those are the questions you are asked. Criminal law. Is that not it? Basic criminal law.
15 to 25 years of jail for an offense is not basic.
Banks and special, no, not the offense, but the law is basic. When you go to law school, the law faculty, criminal law, issues like fraud, defrauding by false pretenses, forgery, and etc., they are basic. The facts are obvious. So I'm saying that the proper angle from which we should be looking at it is gross failure by our Attorney General to protect citizens, and when they have been defrauded, to hold accountable this singular person who has caused this. And the charges are not complicated. The facts are not difficult to decipher. And so I feel scandalized for anybody to even say that we should commend the Attorney General that today, after 3 years.
You said blame Attorney General for not protecting. That was Securities Commission, I think Bank of Ghana. They were the ones.
All of them.
And they issued the statements. They issued the warnings.
They are not just supposed to issue warnings. They are supposed to march troops to the place and shut it down and arrest the gentleman. That's what they were supposed to do.
Okay.
So clearly, there's been complicity at several levels. And now we can also see, without being told in very clear terms, that the office of the Attorney General has failed woefully to carry out its basic responsibilities.
So,
and we are
so
being told that
moving-
we should commend him for now bringing, fresh charges.
So moving forward, on this 19th of September, the case comes back to court. From where you sit as a lawyer, what should be the posture of both the court, the Attorney General, and those involved in this matter?
Listen carefully. These are very simple matters. The charges are simple. The facts are there. There's no dispute about the facts. Convicting this gentleman won't take months if really the Attorney General and his team are serious. As for the issue of tracing the money, that's a completely different exercise. The Ghanaian legal system is interested in somebody who has carried out such crimes to be convicted and sentenced. Those whose monies he took, they are individually interested in recovering their money. So the two tracks can take place simultaneously, concurrently, whatever. But you cannot say that, the Attorney General should just focus on getting the money for us. Right. How about the crime that how about those who have died? What happens to them?
Osman, you are the last person to speak on this, and very briefly. So do you share with the views expressed that by now the state should be updating the customers and all of us how far it has gone in efforts to, as it were, trace the monies, assets that have been confiscated, what has happened, and so on? At least that aspect, not the criminal trial.
Yes, Samson. I think so, and I'm very interested in the distinction Honorable has just brought, because I have been looking for that angle for a long time. The distinction between the criminal trial and the steps that have been taken to recover the money. These are two separate tracks of legal proceedings that must be going on. And so, but of course, I agree. I said yes to your question because if you look at the case, I always ask myself, is Menzgold on trial or number one as a person? Because the whole operation was done through Menzgold. And within our legal system, we know that corporate entities have separate existence and separate capacities.
Yeah, he's been telling the customers that. He's been telling them that they didn't give him any money. They gave it to Menzgold, so they should stop trying to attack him.
That's the point I'm making. So, of course, fraud is one of the reasons for which we can pierce the corporate veil. But I think, it's my opinion, that it is the court that pierces the corporate veil. Now, I don't know if the Attorney General can pierce the veil before the court comes to that determination. And I don't know what is on the charge sheet, whether it is number one that is on the charge sheet or it is Menzgold. But of course, if a corporate entity is convicted, it is the officers of the company or the corporate entity that will also be deemed to have committed the offense. So, separate from the criminal trial, what steps is government taking to recover the money? Because, look, if you ask me, the whole of this thing is as a result of some regulatory failure. Regulatory failure. The government is the regulator. And I don't like it when people want to blame the investors, because the investors, if you are investing in a regulated industry, it is a trust you are expressing in your government for regulating the industry and making sure that it is safe for investment. Now, if the government we hear that some assets of Menzgold have been confiscated. I don't know how true that is, but if assets have been confiscated, it's not like Menzgold continued in operation and came to a point where it became insolvent and then something happened to trigger off what we are seeing today. And it came from regulators. Right. So if regulators have taken steps, they must update the people as to what steps they are taking to recover the assets of Menzgold and distribute it to them as creditors.
All right. Okay, thank you very much. We have two other issues to deal with. Amanda wants to make a small point. Amanda, if you can do that under a minute, and Richard, just about a minute too, so that we can go. Yeah. Hello,
yes, just to clarify a few points. Money laundering charges were in the original 61 charge sheet. There were a few money laundering charges. So just to clarify that point, so that it should have gone to the High Court in the first instance. The second point is, no one is per se saying the Attorney General has done a great job. But, you know, being on the side of people who often have to lobby the government to act, we often have to encourage them for every little thing they do and then hope that they do the rest. So speaking negatively about them and saying they've done a crap job is not going to incentivize the Attorney General's department to do more. So we're happy that they've taken this step. And we're going to do. And then the last point is 5 years. The last point I just want to make is that this operation took 5 years. They were not gullible people. It was for SEC and Bank of Ghana to have shut them down before 5 years. And the fact that they kept them going meant that people thought this was a legitimate operation, and the bigger victims or the bigger amounts came within the last 2 years. So had the regulators done their job in the first 2 years, you know, the bloodbath wouldn't have happened. And the final point is, Nana Pierre-Mensah seems to have properties in different people's names. Some people have been texting me. And that maybe it is for government to incentivize the public that should they have proof of whose the properties he does have in different people's names, etc., that maybe they can have a small reward or something for identifying those properties and telling government about it.
Good idea. Thank you very much. Yes, Richard, 30 seconds.
Samson, I was just saying that we need to stay away from the attempt to politicize this matter. No, please allow me.
Politicize?
No, just allow me. I wasn't referring to you even. I'm just saying that we should stay away from the attempt to politicize the issue, because really, if you look at this whole Menzgold story started in 2016.
Okay, so that's where you take us. Let's move on.
I'm saying. Yeah. So I'm just saying that we should move away from that, because if we do, then we'll have to go back and study analysis.
Thank
but
you.
the assurance I want to give, to clarify,
let's hold him accountable.
The attempt to clarify the point Osman made in respect of some of the assets seized. I think I understand that some of his vehicles
some were seized, some were sold,
and they've been auctioned. The monies are lodged in an account. Some gold bars have been recovered, and they are waiting for determination of the trial. But the point I want you to make for our viewers is that because it's a criminal trial, the substantive case of him having committed a crime.
I think you've made that point, and that's important.
It has to be established.
Thank you very much.
The decision about the asset and what to do with it.
Thank you. That's right. And the convener for the Menzgold people says Menzgold properties were sold in the full glare of the public, okay, so they feel also that the Securities and Exchange Commission failed abysmally in the process, and that's why they are in the circumstances that they are. And some are also suggesting that this is a point where we should begin to talk about the question of unexplained wealth, so that we empower the OSP properly and Shraj to do these things. We will not get into some of these troubles. Then one message here says that the billions that the state has spent on banking bailouts is cited as one of the reasons for the economic difficulties Ghana is in. That is factual. And the culprits are walking free, duping citizens even more, while taxpayers are being asked to pay more taxes. It's unconscionable. There's no reason why this fellow should be out on bail. Actually, it's said that he is with police protection. We'll be right back to deal with the matters of the OSP fighting the order of the court to unfreeze Cecilia Dapaah's frozen accounts and to return the seized monies to Cecilia Dapaa. The OSP says, literally, in the last paragraph of its statement, that it won't do it. How exactly? And IGP Dampari is the worst. He's not correct. What do you make of the police officer who is speaking in this hearing before Parliament? We'll be right back. You're welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile we put Ghana first. My guest, Mama Yarga, is MP Boku Central. Maria Walanada is Executive Director, Ghana Integrity Initiative. Amanda Clinton is Head of Chambers, the Law Office of Clinton Consultancy. Osman Al-Hassan is lawyer and former Managing Associate at Tuguba & Associate. And Richard Ahyagba is Communications Director of the New Patriotic Party. Just a few of your messages here. Komla Fred 1 says, let Namwan come out with a new scheme today. People will still patronize. They will not question the legality or the genuineness of the deal. They only look at the interest and their returns. After all these, people will still pay to get their profile verified. God have mercy. Little Tete says a gold collectible firm successfully duped many of its clients because it was generally accepted by leadership in the country. This compels security agencies to turn blind eye to its nefarious activities, let alone investigate the wealth. Number one has been over-pampered. K. Amofa says, why has the government all of a sudden woken up with a number one case? Justice delayed is justice indeed, is indeed justice denied. Our leaders in Ghana must sit up. And that's from a number of you sharing those views. Okay, Cece, your message is very long. He says, Samson, it is clear that our government, most state institutions over the years have been so irresponsible, non-caring about the plight of the ordinary poor people of Ghana, and they, together with such criminals and corrupt people, have abused the ordinary poor, vulnerable people for a very long time. We don't have credible institutions to hold such criminals accountable, and so they have continued to focus on winning elections rather than putting appropriate measures in place to support the interests of the people. What sort of country is this that allows criminals to steal from the people and state? Okay, so like I said, your message is just too long. Thank you very much for sending them in. Nonetheless, if you make it crispy, we will love that. The Gasma 1 says, is human rights not the very core of policing? If so, why do the police very often see human rights as something that impedes them in their ability to do their job? Many a time, you also find our courts too willing to support the police. Our courts need to sit up. That's in respect of the demonstration. Kenneth Vosa says, democracy with machinations of state institutions is worse than a military rule that sees the progress and development of a country. Okay. Mr. Rhetorician says, I refuse to believe that the police, an institution established to serve and protect the public, even during demonstrations, has become a political tool to stifle citizen rightful dissent against bad governance. It's disturbing. It's a disturbing reality that must be confronted. Thank you very much. The last one here from Al-Haj Suleiman says, while I'm not a lawyer, I think there should be a cause of action in law for the citizens against the state for its failure to protect the citizens. Instead of moving in to close him down, the state behaved like a sitting duck, issuing warnings upon warnings when they knew his operational hideout and could have easily arrested and stopped him. While the citizens have licked their own wounds due to greed, the state has failed woefully and ought to be accountable. I think actually at the beginning of all of these things, Amanda, I think that was one of her angles where she was seeking to have the state be held accountable for the losses of the Menzgold customers. Well, let's now go to the Special Prosecutor's Office and see what exactly it is seeking to do on the back of the order to release the frozen accounts, to release the money seized, and also unfreeze the accounts that it has frozen in respect of Madam Cecilia Dapaa and the case that has gotten so much attention. So the Financial and Economic Division of the Accra High Court, Economic Crimes, has ordered the Office of the Special Prosecutor to return all money seized from the embattled former Sanitation Minister, Cecilia Dapaa. The court orders that its ruling should be complied with within 7 days. The court also said it cannot confirm the freezing of her bank accounts and other properties. Cecilia Dapaa, of course, opposed the application and made a number of claims. The OSP said to facilitate investigations, it considered it necessary for the issuance of a freezing order against the bank accounts and investment of the former minister at Prudential Bank Limited and Societe Generale in accordance with Section 38(1) of the OSP Act and its regulations. The OSP conducted searches in 3 residential properties of the minister and also retrieved some money and wanted that also confirmed as seized, but the court disagreed with the OSP. The High Court, in refusing to grant the OSP its wishes, said that, among others, that the OSP was late in coming because it should have come within 7 days after it issued the freezing order. The OSP has disagreed. I'll read the OSP statement to you shortly. But let's begin with Osman on this one. Yes, you have said that this is wrong. The court's posture is completely wrong. How so?
Something, right? Let me precede my comments with this, that we should all be interested in getting institutions of state work properly. Let me just say this. I say this order is not proper because, one, the special prosecutor or the office of the special prosecutor and the accused person definitely will have a dispute about the date of seizure. The date of seizure. Now, if the office of the special prosecutor is still operating or is still in the process of searching and confiscation, are we to understand that at every instant, every second or minute that it discovers something belonging to the accused person and seizes it, then the time for which or within which it has to apply to the court for confirmation starts from then? Or we are looking at a comprehensive or complete, or the time when the OSP has completed its search and discovery or seizure of everything within the operation. Now, secondly, you will also notice that when a property is seized, there is a provision under the OSP's Act that provides for the management of that property. Now, if an application is made, my question is, if an application is made for confirmation of seizure, is it an opportunity for the court to refuse their application and order a return of the property to the accused person? Because for me, if you look at the Act properly, the two are completely distinct. before the court can return the property to the accused person, it is an application, it must be upon an application made by the accused person alleging certain things itemized under the law. So if the OSP goes to court and said, okay, I have confiscated this thing, it is in relation to someone who I am investigating for corruption or against whom corruption charges are leveled, and the property is tainted, I have reasonable grounds to believe that the property is tainted. Then you refuse to confirm the order. For me, I think it should have stopped there for the accused person to make the application under the relevant provision and now produce evidence for the things that are supposed to be proven under that provision. That the property is not tainted, that she has no interest in that property, or that, I mean, these are the grounds that must be proven for the property to return. And for me, for the court to return the property without going this deep to make this distinction is wrong. Secondly, I look at the impression the courts are giving to the citizenry about the fight against corruption. Now, this is a public officer, and we all know that by law or under law, especially the Public Financial Administration Act, a minister of state manages public funds. So if a minister of state is under a duty to manage public funds, and under the Constitution is not supposed to place him or herself in a position in which his private things conflict with his duty or functions in that public office. Now, if this quantum of money is found in the private room, not in a bank account, of a public person or a minister who is supposed to manage public funds, would it be a reasonable grounds for an OSP to think that this property, which is in his custody, in her custody, is tainted? That is the question the court probably would have to answer. Because if you want to come to the conclusion that there's reasonable grounds that the property is tainted or not, then of course you have to go through this process. What is the reasonability of the charge or the investigation? And then you go to the seizure, the account. The account. Now, the application made in respect of the account is also in a separate and distinct provision within the Act. Now, if what need be proven there? That, look, the person is being investigated for corruption-related offenses. He's been charged. And again, that there is reasonable grounds that the property or the account, what is in the account is tainted. So for me, I am interested in how the court gets to the conclusion that the property is not tainted or there is no reasonable grounds for the property to be seized.
I see. Were you referring to, I want to look for this particular section of the OSP law, freezing of property, yes. Section 38. It says, where the special prosecutor considers that freezing of property is necessary to facilitate an investigation, or prosecution, the special prosecutor shall in writing direct the freezing of the property of a person or entity being investigated. So when you said if you are being investigated, is that enough to hold the money? If you get to section 40, it says issuing of freezing orders. It says where an application is made for a freezing order, the court shall issue the order if it is satisfied that A, the respondent is being investigated for corruption or corruption-related offenses. The respondent, B, is charged with corruption or corruption-related offenses. What will be the justice if the person is only being investigated, they have not been charged, and you are seizing their property? Don't you see that's where the court is thinking? That it's not fair, human rights?
Samson. So are we saying that there was no charge yet?
No, there's no charge. There's investigation that is ongoing.
Okay. So if there is an investigation that's ongoing, and there is a reasonable grounds for the OSP to believe that the property of the person being investigated in relation to corruption-related offenses are tainted, shouldn't that be the grounds sufficient for the OSP to seize the property? Because it is not about the charge. The charge actually is to be leveled and determined in a separate proceedings. These are preliminary measures to ensure that the property in respect of which the OSP is prosecuting or is taking steps or action is not lost, is not dissipated. And sometimes it is supposed to accord the special prosecutor evidence for what it is doing. And so if, for me, the basic...
Okay, I'm losing Osman there. I can move on to someone else, but I'd like to...
If there is reasonable grounds based on which the special prosecutor can come to the conclusion that the property of the accused person is tainted.
Okay.
And so, yes.
Quickly explain this again for me very briefly. What do you mean by the seizure of the money is separate and distinct from the freezing of the account? You were referring to the act again, or the LI, and I'm looking at the seizure of money. It does appear that once they seize the money, and you, the person whose money has been seized, you don't take certain steps within, I think it's a month, you lose the money, you forfeit it. And it appears that by the time the court was giving this ruling, the 1 month has already elapsed, and the Cecilia Dapaa had not gone to seek to get this money back. So that's another legal situation that occurs, right?
Of course. You see, so that's why I said it is up to the person, the accused person, to also make an application and prove certain things that the court must determine before a return of the property. And so there's a time, as you said, there's a time limit given within the act for this to happen. And if the time runs, counting from the date of the seizure, then, of course, she loses the right to now go and apply for the return of the property.
So now that the court has said, unfreeze the money and return the money you seized, and the ruling is coming late at a date when the period when she should have gone to ask for the money has elapsed according to the law, do you see that there's some legal, tussle that will ensue?
Samson, that's why I said these are preliminary stages. The substantive action itself is to be tried and determined in the criminal proceedings. So I believe that the criminal court that is presenting over the substantive matter, upon determining that she is not guilty of the corruption, it can order that the property be returned to her. And okay. So that's why I said, if you look at the way the property should be managed,
so,
in fact, it's even include, yes.
So my final question to you, and I want a very brief answer, but before that, I want to read the OSP's response. It says that the Office of the Special Prosecutor commenced investigations in the third week of July 2023 in respect of the suspected corruption and corruption-related offenses regarding large amounts of money and other valuable items involving Ms. Cecilia Dapaa, a former Minister of Sanitation and Water Resources. When he says they commence investigation, it seems to reply to the court that when you suggest that we are not doing any investigation, you are wrong. We are actually investigating. Then it says on the 31st of August 2023, the High Court, Accra, refused to grant the application of the seizure and freezing orders on the grounds that the confiscation of seizure application was filed out of time, that the OSP did not provide any basis for the seizure and the freezing since it did not disclose the details of the transactions in the accounts. And further, that the freezing order was based on public sentiments and without proper investigation. While the OSP respects the court's decision, it disagrees with the decision of the court. First, the OSP believes that the court's computation of the time limitation is, with respect, erroneous. The OSP searched 3 private residences associated with Ms. Dapaa over the course of 2 weeks. The searches and discovery were ongoing during that period. There is little doubt that the OSP filed its application within the statutory window once the search and discovery window is considered. Second, the seizure by the OSP and the Special Prosecutor's freezing order were effectuated on the very firm basis of reasonable suspicion that the amounts and bank balances were tainted property, as Ms. Dapaa prevaricated as to the source or sources of the amounts she reported stolen from the residence, the amounts discovered by the OSP in her residence, and the volume of transactions in her bank accounts and investment. Third, the freezing order was not based on public sentiment. Rather, it was based on court processes filed in a criminal matter before the Circuit Court, Accra, involving Ms. Dapaa as a complainant. Further, the freezing order was effected to aid the investigation as required by law, not on the basis of the investigation, as indicated by the court. Therefore, it cannot be said that the OSP did not carry out proper investigation to warrant the freezing order. The investigation has only commenced and it is ongoing. The OSP, that's the last point I ask you the question on. The OSP assures the public that it will take all necessary legal steps to ensure that the seizure amounts and the balances in Ms. Dapaah's bank accounts and investments are neither concealed, lost, or otherwise dissipated. What is he saying he's going to do?
Well, perhaps appeal against the decision of the High Court and still withhold the funds as seized, and probably apply to the Court of Appeal to hold off the implementation of the High Court's order to return the properties to the woman. That's the only way I'm looking at it.
But it has the administrative power to continue to freeze the monies, right?
That's why I'm saying upon appeal, if there is an appeal and they file an application for an injunction to restrain the implementation of the High Court order, until that is determined, they have the capacity to hold it.
Okay, thank you very much. Mary, you at the GII earlier issued a statement to support the OSP in its work as it came under, a barrage of attacks from interested persons. What do you say about the events?
Samson, this is one of the instances where it becomes very difficult to comprehend what exactly is going on. We believe the Office of the Special Prosecutor is one who would help this country if we are to fight corruption. And so we mentioned that, and we continue to support them to carry out their investigations and prosecutions of corruption and corruption-related offenses. What this judgment brings to bear is the fact that fighting corruption is and continues to remain a very lonely endeavor. It is a difficult one at that, because we have put around us many legislations and also frameworks that seek to fight back when we are trying to fight corruption. It is so, it's pure and simple, because you realize that in the instance where a public officer, and this has been eloquently spoken to before, a public officer has so much money, huge sums of money in her home, the Office of the Special Prosecutor initiates an investigation and then goes to court to ensure that these monies are kept so that there is no doubt that somebody would go and pick it up. If you remember, this has happened before. I do not want to recount the specific example where accounts were frozen, and when they were unfrozen, Samson, you know, the GI was involved in this in a matter which was taken to charge. This man, the court unfroze and the monies went away. I don't want to mention the names. So it's sad when these things happen, particularly because there is an ongoing...
But Mary, it does appear that sometimes when they are pursuing these matters, when a court doesn't confirm the freezing for them, which is the confirmation that they can keep for a longer period, what they do is that if you say unfreeze, they will unfreeze it, the next minute they will freeze it again. And they have the administrative power to continue to freeze it within those short periods.
And so let's hope and pray that the OSP does that and does it quickly. But that is not to say that we have any credibility doubts. What we want to do is that due process is served and the interest of the citizen is, in this case, upheld. We believe that fighting corruption should be supported by all institutions of states. And when we say that, we mean the adjudication institution as well. We are not saying they shouldn't do their work. We don't begrudge the judge for citing her instances for ordering the special prosecutor to do to unfreeze the accounts. But then we believe that to give some support to the fight against corruption and then disabuse the minds of the people that when you fight corruption, corruption has the tendency to fight you back. And for that matter, we shouldn't engage at all. And also, remember, some of these have the tendency of emboldening public officers to continue to do what others have done in the past. And so not to set bad examples and precedents, we should be seen to be manifestly fighting corruption and not just encouraging people to carry on because the law says so and the law must be upheld.
From what we know, and by what the OSP has done in court, it says freeze this account. I have seen this account and I've seen X amount of money being the cumulative transaction over a period, $5 million and so on, 48 million million Ghana cedis and so on. The OSP, by that, will already have the evidence of the bank statement. So even if it's unfreeze the accounts, can't it use those for its purposes in the court? Or the only problem is that maybe by the time you are finished, the money is finished?
Exactly, and Samson, that would be a very big injustice to the people of Ghana. We need to ensure that whatever is frozen is kept intact, so that at the end of the day, if there is culpability or that it is being found that the person is free, then she keeps her resources. But then we do not want an instance where at the end of the day, the state is shortchanged. So let us ensure that we are protecting the interests of the citizenry. while also engendering trust, because that is the issue. And let me say that in many of the instances, our politicians have not also done as well in many of these instances. Let us all speak against this. Let us all stand united that we want to have some very good precedent being set for the people of Ghana.
All right.
So that when we are talking to issues around public officers, be they around ethics or criminality, we talk as a collective and not as the disjointed units. This would not help us, and it is beginning to erode trust. And when trust is eroded, we have a lot of challenges convincing our citizens, and we have seen around the continent some of the mishaps and some of the happenings. We do not want to get there. We want a system where we can trust, a system which is formidable, a system which every ordinary Ghanaian can rely on, that we do not go to public office to amass wealth. Either we are suspecting it of being the case or it is actually so.
Okay. Mama Yarga, so what are we saying? You're hearing too many people who are disappointed in the court and so on and so forth. But it is the legal systems, the same legal system that is being used to fight corruption. So it cannot be, yeah, okay, go ahead.
We can be very emotional and sentimental because of the background. But I like to be very, very honest and frank in dealing with any given situation. I have read the press release of the special prosecutor. Mm-hmm. And I want to say that we are not small children. Read his statement. What does he say? In paragraph 3. While the Office of Special Prosecutor respects the court's decision, it disagrees with the decision of the court. First, the OSP believes that the court's computation of the time limitation is, with respect, erroneous. That's actually the most critical paragraph in this statement. The OSP searched 3 private residences associated with Ms. Dapaah over the course of 2 weeks. The searches and discovery were ongoing during that period. There is little doubt that the OSP filed its application within the statutory window once the search and discovery window is considered. You see, I am not a fan of Cecilia Dapaa. I don't think what she has done is right. But I was in Parliament and I participated in passing this law. If you look at Section 32 of the Office of Special Prosecutor Act, 32(2). 32 gives the special prosecutor or his agent the powers to seize.
To search and seize.
Search and seize what is suspected to be tainted property. Okay? But 32(2) says that the special prosecutor shall apply to court within 7 days. Within 7 days to confirm the seizure. This is somebody's private property. And if you take it, we say run to court within 7 days and confirm the seizure.
That's in 32(2).
Yes, confirm the seizure.
The special prosecutor shall apply to the court on notice within 7 days to confirm the seizure.
Exactly, that's what the law says. Now, this third paragraph, convoluted. There is nothing in that paragraph in which the special prosecutor is saying that from the date to when we ran to court to apply for the seizure, it was 7 days. We're not talking about when you went to search the property. We're not talking about how many properties you searched, whether you searched 3, 4, 5, whatever. Whether it took you 1 year to do your searches, it doesn't matter. The specific date that you seize this particular item, that is the date we are supposed to start counting from. After 7 days, if you haven't gone to court to confirm it, you have breached Section 32 of your own act. So he shouldn't try to throw dust into our eyes. If you are negligent, admit that you are negligent. If you haven't performed your task as expected of you, admit that you have not performed your task. The judges are there to protect the rights of everybody, just as to also ensure that you exercise your powers properly. So did the special prosecutor run to court within 7 days of seizing the property or not? That's the crucial question that has to be answered by the special prosecutor. If he did not, why didn't he? In the face of 32(2), which clearly says that for him to continue to hold that asset, he must go and have it confirmed by a court. If he didn't go, he can't come and be throwing dust into our eyes. And if he didn't go, he only knows what motivated him not to go within the statutory period.
32(3). If you read further, it says, where the special prosecutor fails to prefer charges within 60 days after the seizure, the special prosecutor shall release the seized property to the person whom it was seized. How do you reconcile this with 32(2)?
No, it's very simple. You see, you seize property not because you have convicted somebody. You seize it in the course of investigation. So we're not saying that you must have concluded your investigation before you seize property. No. In the course of the investigation, if you have reasonable cause to believe that this property is likely to be tainted, then you should run to court after 7 days of taking the property to say, look, I suspect that this property is tainted. Look, I'm investigating her. She was a minister of state. Every year she had a budget of $100 million to make sure that the city is clean, and then, water contracts are awarded. She awarded, contracts for the cleaning of the lagoon and etc., which cost, $100 million and etc. So she managed public money. Okay? Now we found money in her house. We suspect that it could be the proceeds of corruption. But we are still investigating. So can you allow us to keep this money so that we can conclude our investigation? If we conclude that no, she has given sufficient explanation for the source of the money, we'll give her money back to her. But if she is not able to give sufficient explanation, we're going to prosecute her. And whilst we are prosecuting her, please allow us to keep the money. Otherwise, if you let her hold this money, get hold of this money, and then we convict her, and then we go to now seize the property because it belongs to the state, and then it is no longer there.
Is the special prosecutor not telling you that?
Listen,
you by how you say it should be computed?
Yes.
That is where the court is wrong.
No, the court is not wrong.
He's saying from here that if you are taking our last day into consideration, then we did 2 weeks of searches.
No, I'm saying that.
Which 2 weeks of searches? You should not be counting that. You are saying it is the last day, the day you declare the property as seized.
The issue is not searches. The issue is the moment that you seize, you took possession. Seizure is when you take possession of the property.
It's not when you declare that you have seized it.
When you took possession of the property, and when you deprive the owner of possession of the property, that's the moment at which you have seized the property.
Okay, so this last one, let me bring in this last one for you to help us, because I referred that to...
Go to the definition of seizure.
I'd referred that to Osman too. Regulation 15 of its regulations. Seizure and detention of currency suspected to be proceeds of corruption. Where an authorized officer seizes currency suspected to be proceeds of corruption, that authorized officer shall complete a currency seizure form as specified in Form 4A of the first schedule and issue a currency seizure notice in accordance with Form 4B of the first schedule to the suspect pending investigations. The form says Form 4A and B. Form 4A, it just says give your name, whatever, the type of currency, the amount of money, the denomination, and the condition the money is in, and so on, and the day in which it is taken. Then the Form 4B says currency seizure notice. So you give this to the person. It says take notice that the under-mentioned amount of currency is liable to forfeiture, and you should, within 1 calendar month from the date of this notice, give notice in writing to the office. In default of such notice, the currency shall be deemed to have been lawfully forfeited to the state. If you give notice of claim or intended claim within the time specified above, legal proceedings for the forfeiture of the currency will commence. How do you take this in addition to 32(2)? It says give them a notice, seize the currency. The notice is for 1 month, correct? 1 calendar month. And it says within that period, you whose money has been taken, you must make a claim. If you don't make a claim, the money is deemed to have been seized to the state.
You see, the Parent Act makes provision for the person seizing the property to notify the person's property, the person whose property has been seized.
That's right.
And give an account of exactly how much has been seized. There's accountability mechanism there. So the regulations is simply trying to define the mechanics of achieving that. For me, that is not the issue. The issue is when is a property seized? It is seized when you take possession and deprive the owner of possession and control of the property. That's when a seizure has taken place.
Okay.
When must you apply for confirmation? You must apply for confirmation within 7 days. I'm saying that the special prosecutor did not do that. He has been negligent. Okay. He wants to throw dust into our eyes.
Thank you.
By issuing these long, convoluted statements.
Yes. And
the courts are there to protect everybody.
The conclusion is...
So let's not blame the court.
The conclusion is what I'm asking your view of, and I'll go to Amanda too about that before I come to Richard. He says he assures the public that it will take all necessary legal steps to ensure that the seized amounts and the balances in her accounts and investments are neither concealed, lost, or dissipated.
I disagree with the court. It's not that I agree with the court for rejecting the application.
Oh, how?
No, the reason is simple. That, you see, the court should have a discretion to say, well, you've come late. But every evidence here shows that it is likely that this is tainted, property. So even though you've come
the
out
court
of time,
not be prejudging the whole matter.
Exactly.
Oh, well, I mean, the suspicion of reasonableness. See, the judge has to take a decision that, yes, it's reasonable to suspect that this is tainted property. Okay? The judge does not conclude that way. The judge says that, no, I disagree with you. I think that you just came here because of public sentiments. How's that? We all know the facts.
Is
of
it
course,
not
the public is a public sentiment wrong? Is it not founded on facts? The public sentiment is founded on the fact that this is their minister of state. Annually, throughout her period as minister, she was given huge amounts of money to manage public assets, acquire assets for the public.
All right.
Is that okay? Now we have found millions of cedis and dollars in her residence. In fact, she is the one who first complained that some of it has been stolen. And from the fact, she doesn't seem to know exactly how much of it was stolen. Then special prosecutor comes in, and then they found other monies that are not kept in the bank, monies that are kept at home. So, prima facie, any reasonable person, but why are you keeping such huge amounts of money at home? Why? Why are you hiding it?
What's the crime in that?
No. Well, it raises suspicion. If you, a private legal practitioner, you decide to keep $10 million at home, and we come, is it our business? All we'll be asking for, okay, well, where did you change the money? Give us the Forest Bureau at which you change the money, or give us
because
the bank
he's a public officer.
Because you're a private person, you're running your law firm, okay? Unless maybe we suspect you of doing drugs or you are doing money laundering. We may ask you where's the money coming from? Maybe
I need just 30 seconds.
Briefs in which you are
I need just 30 seconds on
millions
this.
Of dollars.
I need just 30 seconds on this. Do you think that it was fatal somewhat to the OSP when it didn't exhibit, for example, the accounts it was freezing, to say that we have seen this transaction. This transaction is suspicious. We have seen that transaction. This amount came from X to this account. But
you see, if it is money in an account, okay, you will expect that the special prosecutor will first check to see where is the money coming from. So if there's a transfer of money, and then you will ask the person, what is the source? What transaction generated this transfer? So if she sold a house she inherited from her father,
she'll explain.
And then she explains, oh yeah, I sold this house, these are the documents.
There'll be a narration in the account.
The buyer
anyway.
is in London, he transferred the money to me. The narrative is there. If there's such a narrative, on what basis are you freezing that account?
Okay.
So the fact that you suspect her of having committed offense doesn't mean that her entire economic and financial life should be strangulated.
So my question is that was it fatal not to exhibit the account statement to point out and say, I've seen this transaction?
I think it is.
It was?
I think it is. I think it is derelict on the part of the special prosecutor not to have at least done some basic analysis of the account statement to be able to ascertain the sources of the monies in the account.
Thank you
so
very much.
I will treat the monies in the house differently from monies that are found in an account in the bank.
Thank you very much. Amanda, and I want to do very brief with you guys. We take a break and we come back and see whether or not the police, there's some trouble for us there. When the special prosecutor almost says in this statement that it will not release the money, what do you think it is saying?
That probably they're going to try and reapply again. Hi, can you hear me?
Yes.
Yes, probably they're going to try and reapply again. But I think the most crucial point of all this is the fact, the statutory window and the computation of the time limit. Because the court is saying, should Mrs. Dapaah's counsel have won, it is based on technicality, and it is for the special prosecutor to prove otherwise. Furthermore, in accordance with Section 38(2) of the Act, the special prosecutor shall within 14 days after the freezing of the property apply to the court for a confirmation of the freezing. And so here they're saying that 3 properties were searched over the course of
2 weeks.
2 weeks. But then also they have to apply within 2 weeks. So that's one point. If Dapaah's counsel won, it was on technicality.
Yeah. The seizure, the timeline for the seizure is 7 days. It is the freezing that has 14 days.
Yes. And furthermore, I think it was a bit too far for Mrs. Dapaah's counsel, apparently, at the virtual sitting, to say that it's an arbitrary exercise of power, misrepresentation of facts, and a media frenzy. I mean, this is in no way a media frenzy. It is in the public interest when you can classify something as tainted based on the volume in the accounts, the amount she reported missing in the property, and the amounts that they seized. It's certainly reasonable suspicion that has been raised. But again, the special prosecutor should know their own act and adhere to it in terms of computation of time and time limits. And if they think the court has got it wrong, then simply go back to court and revisit it.
All right. But an important thing, the judge seems to suggest that, what are you talking about when you say you are investigating corruption and corruption-related offenses? What exactly is that? Even though the OSP Act says when you are investigating corruption-related offenses, can you actually put somebody in court under a charge of corruption-related offenses?
No. You can't.
Well, I think the special prosecutor has definitely made its case in terms of just the volume in the accounts again, and the amounts she reported missing, and the amounts that were discovered in the property. As a public officer, it raises more than reasonable suspicion. And the case has not in any way been concluded. These are preliminary matters.
Right.
And because it's preliminary, it is down to the special prosecutor to go back to court and say how they were somehow within that time frame.
Yeah.
And if it's true, then, but it is also a lesson for the special prosecutor. They must know.
Yeah, so according to the Special Prosecutors Act, Section 78, corruption and corruption-related offenses is the general rubric and not the specific offense.
79.
Right, 79. It then provides the specific offenses. So do you think it is easy for the special prosecutor to go and tell a court that I'm investigating corruption-related offenses, and a judge will take that seriously?
Yes, because again, the freezing and seizure actions were based on reasonable suspicion that amounts of money in the account were questionable.
For which specific offense? That's my question. For which specific offense?
Well, they cited the fact, the volumes in the account for a public officer, the fact that she said that a certain amount was missing, which was a very high amount, and the fact that they kept on discovering very high amounts of money in these searches.
Okay.
So I think it raises a suspicion if she is a public officer, and so basically the freezing means they need to hold onto it and determine exactly what took place.
All right.
Because what happens for things like it will dissipate.
All right. Thank you.
The money will go if they don't freeze.
Okay.
Basically.
Thank you very much. And I was asking her that because we know generally in our jurisprudence that to the power to freeze and seize money and so on, it's normally triggered under a specific offense. That's why I was just asking that. So what will be your brief comments?
Well, whilst you're doing that, I think myself and Honorable Ayaraga were looking at the specific offenses under which those actions can be taken. But I think that the special prosecutor has been very untidy with this whole case and getting its lungs filled with the oxygen of public interest in the matter, and is affecting how it should approach this matter. It's a straightforward thing of establishing whether or not any corruption took place. So the primary controllable for the special prosecutor is investigation. Now, Samson, if you investigate and establish that the monies were procured or acquired through dubious means, leveraging her public office to do so, then a crime, having established that beyond reasonable doubt, a crime may be seen to have been committed. And so therefore then, measures to freeze, to seize, will be inevitable, will be naturally occurring conclusions that all of us...
This law, the OSP law, does not require you to have finished an investigation. It says you can come when the person is being investigated, having been charged,
I don't dispute
being
that
prosecuted.
Yes, I don't dispute that at all.
Okay.
But I'm saying under the present instance where he's seeming to be battling back and forth, there's a primary business that he has to do, right? Is to ensure that he conducts the investigation. In fact, even in the case of the monies in the bank, supposing that the money would dissipate, for me, is unthinkable because any money taken from the account can be traced. And then the person with her reputation and standing in society, it's not as if she's just going to disappear and go anywhere. So if you are interested...
Criminal investigators don't do that too.
Well, I understand.
They want to protect the money first.
But I'm saying, I agree. So I'm saying that there is a reputational matter to be taken into account.
Okay.
So therefore, if there was anything now, with her standing in society, she has that recognition to be given the benefit of the doubt. But what I think the special prosecutor is drifting away from is the focus on the matter, because I have personal interest in ensuring that this matter is investigated expeditiously.
Okay.
Because it has implication for my party, it has implication for the Madame Cecilia Dapaa herself and her reputation and family. So the special prosecutor should save us all this agony by focusing and investigating, if he has the capacity to do so, and establish cause to say that these monies are procured or acquired under dubious means. So then we can proceed. These other back and forth about it is here, I'm freezing and all of that, for me, it is playing to the public gallery.
Really?
And I have, yes. See, from day one. My concern about it is that, look, why
we are talking, you just spoke about Namwan a while ago.
Right. Yeah, so
Ioko had to move in, freeze the assets, hold them so that they are not dissipated. As we talk, we speak.
But
there's many more.
I agree with you.
That the state wishes that it could know the sources and go and hold on to them.
But you know that even in law, personal recognizance of an individual is key, right? So with Madame Cecilia Dapaa, that recognition exists that she would not do anything untoward.
No,
in fact,
but the money, you don't trust to that extent.
I agree. But I'm saying that that's a small point, right? It's a minor point. And I'm saying that the big point and the main issue of preoccupation is the establishment, of course, of that money. Because you cannot suppose that because she has that money and she's a public officer, she cannot earn that money. That dangerous supposition for me is what is something that we need.
You don't know it's a dangerous supposition. They are privy to bank accounts. You don't. So you can't
But you know, for me it's dangerous because it comes in summarily to say that there is no way that Madame Cecilia Dapaa can earn that money. It's a dangerous supposition.
Who says that?
I'm saying that the supposition is on the basis, and that suspicion you are saying, is on the basis that there's no chance in this life that she can earn that money legitimately.
That's what I'm saying.
Which is false.
You and I are not privy to the accounts they are looking at.
Yes, I don't.
And the monies that they seize from the house, you don't know what led and the processes towards the seizure of the money. And how they were found in the house. You don't know. We don't know.
Well, I don't understand that. But I'm saying that
whether the monies were hidden, whether they had to take them extra effort to discover the money, you don't know.
But I'm saying that, given all that matters that you're saying, the basic supposition that we suspect, and in fact, I don't want to read, Honorable talked about the first point in relation to the time limitation as the most crucial point here. I think that the second point is equally crucial, and one that for me I find very objectionable to suggest that, and this is where the supposition actually comes in, saying that their basis, one of their bases, to want to move and seize the account or freeze and seize the account is on the basis of her prevarication. Now, to say on that, the assumption there is to say that she's prevaricating, she's being evasive, she's not telling the truth, she's beating around the bush. I find that in reference to an honorable person like Madame Cecilia Dapaa as objectionable. Okay, to the extent that you have an investigation to carry on the investigation. You have your law to comply with. If you fall within the limit of it, then go ahead and get the order confirmed or not. But here we have found he's not been able to adhere to the law. Now, number two, having failed to adhere to your own law, you are making suppositions that are dangerous in the sense that you are trying to smear the individual, you are trying to prejudge the case that she must have done something wrong, and so we must hold the money. I find that to be very objectionable. The truth is that I support, and all of us support, the special prosecutor. He's been doing a very nice job, but the objection I take to the work that he's doing is the exceeding publication of the work in the media. As a citizen, we are not interested in all these discoveries or scoops that come out. You should go ahead and do the investigation. What we are interested in, or should be interested in as citizens, is to say that he has resolved or preempted a corruption case by recovering money for the state. You know, what part of his function is to contribute to revenue generation. So therefore, if he does that, and recover monies that belong to the state, otherwise in people's pockets, in people's accounts. That's what we're interested in, is to take less interest in this media publicity and focus on the investigation. So for me, Samson, right now, even with the court's ruling to have him take his hands off the account and the money, it does not in any way impede the special prosecutor from proceeding with the investigation, because that is what he can control. So he should move speedily to investigate and establish cause if possible, and then all of us then will come to this table and commend him for what he's doing, and then ensure that people cannot abuse the resources of the state. But for now, what he's doing is for me, very dangerous opposition, insinuating and impugning people's integrity by suggesting that they are being evasive, and so therefore he wants to exercise the right, whether he's complying with it.
Which case are we talking about? Which case are we talking about?
I'm talking about Madame Cecilia Dapaah's thing. That he feels that because Madame Cecilia Dapaa, in his view, is prevaricating or for more or less cannot establish.
Is it a feeling?
Huh?
Is it a feeling or is it a fact?
I'm saying that, no, but what is the basis for establishing that?
We know
Yeah.
that there have been a charge sheet in the court,
Yeah.
in the criminal case.
I know
which
that,
charge sheet, hold on, which charge sheet has suffered 3 different amendments?
Right.
In which there was a case that
but that has nothing to do
how
with the
much
money
belonged to who.
That has nothing to do
That's
with the money in the account.
That's pre-verification.
I'm saying that is to do with
So it's
the
not
money.
a feeling, it's a fact.
Hold on, I'm saying.
Okay, let's do this quick. Let's do this quick. Let's do this quick. We're joined on the line by Sami Dako of the Special Prosecutor's Office. May we understand, the intervention as far as the discussion is concerned?
Yes, thank you very much, Samson. Yes, the Office of the Special Prosecutor at this stage is investigating Ms. Dapaa. The Office of the Special Prosecutor at this stage has not concluded and said that Ms. Dapaah's property are tainted, nor is she guilty of corruption and corruption-related offenses. Now, what the Office of Special Prosecutor does is that we do investigate corruption and corruption-related offenses. When we have finished investigating, then we will charge you with specific corruption offense. For instance, we will charge you with the abuse of office. Or let me use the cases that we have in court. So if you go to Kumasi, we are currently trying the former nominee for corruption. If you go to Tamale, we are trying the former chief executive and the 2 deputies for abuse of office and other corruption offenses. If you go to Accra, we are trying the PTA boss for abuse of office and other offenses. So when we are investigating, we have not charged a person. When we arrest you, we caution you and we start investigation. What our law says is that when we think that the property is likely to be tainted, we should go to court after administrative freeze to then confirm the freeze. We have 14 days. And in this particular case, we were within the time of 14 days. So we were there on 14 days. And the requirement is that the court, when it is satisfied that there are several options, about 4 of them, on which the court can say, I'm not going to confirm the freezing order for you. And if you give me just 2 minutes, I'll read them. The first one is that if you look at 42.1, it's called issue of freezing order. Where an application is made for a freezing order, the court shall issue the order if it is satisfied that 1A, the respondent is being investigated for corruption or a corruption-related offense. B, the respondent is charged with corruption or corruption-related offense. C, there are reasonable grounds to believe that the property is tainted property. D, the respondent derives benefits directly or indirectly from corruption or corruption-related offenses. Then there is C. And then the last one, which is the F, there are reasonable grounds to believe that a confiscation order shall be made under the Act. Now, the question you ask yourself is that we came under A, that Ms. Dapaa is being investigated for corruption and corruption-related offenses. So if the court wants to say that we will not confirm, then the court should be able to give reasons why the court thinks that Ms. Dapaa is not being investigated for corruption and corruption-related offenses. That is why, in our estimation, we say that we should agree with the court. Because the court has to give grounds within what is in our law.
Yes, that's about freezing and within
Exactly.
14 days. How about the money that was seized?
Yes. So the money that was seized, as we have already indicated in our press release, the issue was ongoing. Now, we understand that people will say that, okay, so the day that you see it, 7 days, you immediately go to the court.
That's what the law says.
Yes. But if you read the law that Honorable Ayariga read, if you read the third one, I noticed that he didn't answer it. Have you noticed that the law says that the property can be with us for even 60 days if we decide not to do anything about it? Now, the other issue I'll raise is that at the hearing, lawyers for Menzgold Dapaa, in the affidavit, had wanted to raise a preliminary legal objection. They did not raise it. So we were able to move the application. That if you wanted to raise that, we are out of time. You did not raise it. The application was moved. Or the judge should have insisted that that preliminary legal objection should have been raised and ruled upon.
But the preliminary legal objection they intended to raise, did they depose to it in the affidavit?
They deposed it in the affidavit, but as you know, it should be raised before we move the motion. But we did not raise it, and we've already removed the motion.
Okay, thank you very much. But the most important thing we wanted to know from you is this. Your last paragraph, you say that you will make sure the money is not concealed, dissipated, and so on and so forth. The order is that you should release it within 7 days.
As the special prosecutor indicated, we are going to comply with the order of the court. But as you also know, we also have several legal avenues available to us to ensure, as we have said, that the money is not dissipated, neither is it taken away. And you are aware that there are several options we have.
An appeal?
No, in this instance, there is no talk about an appeal. There is nothing like an appeal.
You unfreeze it, in the next minute you freeze it. She'll be standing by her account. Immediately you unfreeze it, she takes it out.
Samson, I think what the point that is important is that OSP is saying that we will use every legal means available to us.
Okay.
There are several legal means available to us in respect of the seized money,
okay,
in respect of a freezing account.
All right.
And as we have indicated, we will make sure that we use every legal means available to us to ensure that the seized money is not returned. Something, if you just indulge in just 1 minute, the whole idea of preservation order is just to help us do our investigation and be able to tell Ghanaians that indeed these amounts are tainted or not tainted. But a lot of people are going ahead of themselves and behaving and believing as if OSP is saying that the monies are tainted and we are now going to court. No. If we believe the monies were tainted, we would have charged Mr. Dapaa straight away. It's because we do not know.
As for the money being tainted, you guys have said so. It's not the public that is saying so.
No, it said you suspect that it's tainted.
Okay,
if you don't suspect it's tainted, then
all
you
right,
don't need to investigate.
All right, thank you very much. Samidako is with the Office of the OSP in charge of strategy and communications. Thank you very much. We take a break here. And when we return, very limited time, I'm going to hold you to just 2 minutes each of a comment on this IGP thing that is going on about a plot to oust him.
Let us understand the issues clearly, Mr. Chairman. I will not be a hypocrite. We have it. And we have some of our people who resigned within 2 weeks and they went and contested for MPs when they were supposed to have had bearing members for 5 years. But they resigned within 2 weeks, they were contesting. Somebody can fake my voice. But I can't confirm because I don't have that technical system to confirm it.
Is there any flow of conversation?
Our own people. So in the police service, do we have policemen belonging to the MPP and another group belonging to the NDC? Let us understand the issues clearly, Mr. Chairman. I will not be a hypocrite. We have it. And we have some of our people who resigned within 2 weeks and they went and contested for MPs when they were supposed to have had card bearer members for 5 years. But they resigned within 2 weeks, they were contesting. I'm not a hypocrite. I'll speak the truth. So as we speak, our police service is divided along political lines. That's the impression I'm getting, and I believe a lot of people watching are getting the same impression. Is that the case? That we have MPP group in the service, and then we have NDC group.
With a great deal of respect, let's have in camera with this. This is okay. It's as you speak now, the Ghana Police Service is divided along party lines. That's a very explosive thing. Yeah, so please, in good time, we can have him in camera.
As we speak, majority of police officers are not happy. And if the same people are those who are going to police the elections, and remember, police officers, they vote. Their wives vote. Their children vote. Their mothers and fathers vote. That is my concern.
Right, so there is the probe that is going on in Parliament over the leaked tape in which 3 police officers are captured in conversations with Chief Bugri Nabu and suggestions about Dampare not being reliable to assist the governing party to win elections. And the particular, COP Alex Mensah, you just heard him, was also lobbying sort of to be IGP and not being happy among others. So what's the relevance of what the committee is doing really? Now, Bugri Nabu has admitted the tape that is authentic. Alex Mensah, COP Alex Mensah, who has, I think, until when, just a few months to retire, right? Also has admitted, but says he's not admitting it in whole. He believes that portions of it, are doctored. And when he's asked which particular portions, he's unable to state with any accuracy. My guest still here on the show, Mahama Yaraga, MP Boku Central, Mary Awolanada is Executive Director, Ghana Integrity Initiative. Amanda Clinton is Head of Chambers, the Law Office of Clinton Consultancy. Osman Al-Hassan is lawyer. And Richard Ahiagba is Communications Director of the New Patriotic Party. Very limited time we have indeed, so I'll see how they can deal with this. The show is brought to you by Bank of Africa, as strong as a group and close a partner, MTN everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 31 years. Duraplus, how you get your water matters. Remember, where Duraplus goes, water flows. DBS Industries, roofing, Papa Fie, and My Way. Dial *165# on MTN to join My Way today. Cherry Tree Properties, we develop spaces as though we were going to occupy them ourselves. Syntex Tanks, it's strong, it's tough, and Flamingo Paints, simply superior. On this matter, let's begin with the MP, Mahama Yarga. Yes. So what's the end? To what end? Now they have admitted, yes, we are the ones talking that the IGP is not correct, let's remove him, he will blah, blah. So what?
Well, I mean, that's a legitimate question. And so what? I think that it will just enrich the discussions that have been taking place around the question of how do you get a less politicized security services. That's a very fundamental question. And I think that the revelations made by a retiring senior police officer cannot be swept under the carpet because he's lived it through and he's made it very clear that we have a highly politicized, not just politicized, but partisan politicized. That's the danger. It's not a police with a high political consciousness. In fact, a police with a very high political consciousness is a good thing. But a police with highly partisan consciousness is a very dangerous thing.
Is that a secret?
Well, I think that it's been heightened in this debate.
Which IGP became IGP without lobbying the politicians?
But that's one of the discussions, whether or not you should take the appointing power out of the hands of the president because he is politically tainted. And so he's likely to give you an IGP that is also politically tainted. And so this provides avenue for us to enrich that discussion and take a decision as a country. In some jurisdictions, what is called the sheriff is actually elected also.
Yeah.
So it's political. It's elected. So there are situations where elected sheriffs have delivered well. So it's not the case that because of the partisanship you are incapable of delivering. If you're not delivering, maybe it's the systems. So let's start. What are the systems? How do you recruit the personnel? It's on record. Some of my colleagues in Parliament have called for an inquiry into the recruitment processes, into the services, because we believe that the recruitment is largely driven by partisan considerations and not considerations of professionalism, competence, aptitude, skills, and etc. So you could be an elected sheriff, you could be an IGP appointed by the president, but if you pay close attention to the systems that generate a very professional police service, you could end up with a very professional police service. But that's not what we are seeing. And the man he's lived it and he's telling, look, the system is spoiled. And so we should be very careful. I had a discussion on one of your sister stations yesterday, and he said, the man says the IGP is very incompetent, and you guys in the NDC have been hailing the IGP. I said, well, I mean, I don't know who in the NDC has been hailing the IGP, but if the man says the IGP is incompetent, I will say maybe he is incompetent because in the past I could demonstrate through Makola, and today I'm being told that I cannot demonstrate through Makola, so maybe that's evidence of the incompetence.
All right, thank you. Mary,
so maybe he's right.
Mary, what do you say? The Police Service Act, Section 17D, is on misconduct and unsatisfactory service. It says that it shall be misconduct for a police officer to engage in any activity outside his official duties, which is likely to involve him in political controversy or to lead to his taking improper advantage of his position in the police service. My question is, this investigation, to what end? They have admitted we are the ones on the tape, so what?
I believe that this is an opportunity for the service itself to begin to then put in place measures to sanitize itself. Admittedly, the politicians from the majority and minority party, as we have, are the ones who have bred this monster for us. It is a fact that it's been spoken over time that they have infiltrated the service with their supporters, and we have seen a lot of things happen in the service which show that it's not people who are interested in serving this nation and promoting service with integrity that have gone into the police service. However, the service itself can do something to ensure that they begin to sanitize them. And one would be, Honorable Mama Ayariga has spoken to recruitment. However, they are the same people behind the scenes pushing their constituents to go and join the police service. And I'm not leaving out the other parties. Both are equally guilty and culpable in this instance.
All right.
Let us begin to allow our systems and institutions to work. I read an article by Professor Aye where he talks about issues of saints, demons, wizards, and systems. And he talks about issues around policy failure. And this is evident of what Prof. Aye talked about. In another one, on ground. The politicians, and yet they are not allowing the system to work. Then they begin to talk outside, and they do the opposite.
We certainly will need another time to deal with this. You have just a minute.
Well, I mean, two issues. The evidence of this hearing suggests to us that this whole issue of the IGP is a matter of internal political jostling for interests. People want to be IGP and things like that. So it's nothing more, as initially was perceived to be, there's a grand government party agenda at all. It's not. It shows that people are in the police service who dreamed or dreamt to become IGP, and so therefore they are sidestep or their particular skills.
He says he started lobbying for the IG position for a long time now.
Right, there must be a reason why he hasn't gotten it, and the wisdom of the appointor
have been confirmed.
Well, I don't know about that one.
Have been confirmed by what he's doing.
I don't know, but to the extent that he's interested, he's not a neutral party, and I'm happy about that we have established that it is their own police service politics, and therefore has nothing to do with us. And the only thing I want to also underline is that the establishment, the confirmation by Bugri Nabu about all that stuff, his involvement is in no way, no shape, no size reflective of our party's position. He may be engaging as a regular private citizen, a member of our party, a former leader. But
so this hearing is of no use?
Well, I mean, to the extent, I think I agree with Honorable Ega, to the extent that it's telling us something about the police service that we ought to deal with and be mindful of. I think that is useful to that extent.
Thank you.
But then the joy for me is that it is not a political thing, but it is an internal jostling that is bringing up these issues.
You can clearly tell when it comes to producing the report, when the committee is over, because they are divided. In fact, you listen to the questions that come from both sides of the committee, and you can tell each one is watching their backs, as in their party's back. Let's see how it goes. Thank you very much to you all, my guests, who have made the time to join us. Unfortunately, we are unable to go to Osman and Amanda any longer. Richard Dahiagba is Communications Director of the New Patriotic Party. Osman Al-Hassan is lawyer and former Managing Associate of Atatuguba and Associate. Amanda Akoko Clinton is Head of Chambers, the Law Office of Clinton Consultancy. Mary Awalana Ada is Executive Director, Ghana Integrity Initiative. And Mahama Yarga is MP, Boku Central. I'm Samson Lardy Anyenini. And my outfit, as always, is by Habil Scooter. You can contact them at Jirangano Gate, East Legon, or call 0200 84 19 88. And the other thing I really love to do, tomorrow Sunday at 2 p.m., join me on The Law. We are talking about how people decide to besiege courts. And as you have heard happening in Tamale, it's not the best. How do we stop it? Because justice must be brought to the doorstep of the people. As the judicial service is opening more courts in remote areas, if the judges are going to be attacked, what can be the case? Thank you very much.